hear me? I'm Brett Del Porto from the Criminal Appeals Division, and I am going to be Master of Ceremonies and Facilitator, and most scary, the audiovisual wizard for this presentation. Today, what we're going to do is and as you can see, we're here for oral argument, and we're going to do a little bit. Che is going to do a little bit on opening and closing statements. I have several film clips that I'm going to try and show, and I couldn't find any really good trial court arguments. I don't know. Maybe Che can tell me why that would be. I think part of it is just that most Supreme Courts, interestingly enough, have video that streams out, and even some of the trial courts do in some states. In any event, I'm very happy with the panel that I have today. We're going to have each panelist give a short discussion on oral argument techniques, and then we're going to go into the film. I will do introductions. Here at my right is Mr. Ryan Tenney. He is Assistant Attorney General. He is in the Division of Criminal Appeals. Graduated from BYU Law School in 2003. Clerked for a year with Judge Norman Jackson of the Utah Court of Appeals. He was a litigation associate for 3 years with Howard, Lewis, and Peterson in Provo. He joined the AG Criminal Appeals Division 5 years ago. And that's all the information Ryan gave me because he's a humble guy, but I feel compelled to point out what a respected member of our division Ryan is. He's both a great oral advocate and he's a great writer too, and he won our coveted Best Brief Award in 2007, was it? 2008. To his right is Che Arguello. He is in, what is you have a new title, right?
I'm in the Mortgage and Financial Fraud Unit.
Okay.
Part of criminal.
He's 1995 graduate of the University of Utah and a 2000 graduate of Cardozo Law School in New York City. Following law school, he joined the New York County District Attorney's Office in Manhattan and served as a district attorney served as a prosecutor for 10 years with an emphasis on violent crime. He was a member of the Homicide Unit, Sex Crimes Unit, and the Domestic Violence Unit. He moved back to Utah in the fall of 2010 and joined the AG's office in December of that year. And since that time, he's worked in the criminal division. He's currently the section chief for the newly formed Mortgage and Financial Fraud Unit. And I have to point out that he's also a new dad for the second time 4 weeks ago. Ruby Arguello.
Ruby Arguello. I'm a little tired, so forgive me.
To my left is Judge Michelle Christiansen, Utah Court of Appeals. She was appointed to the Appeals Court in 2010 by Governor Gary Herbert. Before her appointment, Judge Christiansen served as a 3rd District Court judge since May 2007. She received her law degree from the University of Utah College of Law in 1995, which makes us colleagues, although I should say I remember you. I remember you. I remember you a lot.
My maiden name.
After which she served as a judicial law clerk for 1 semester with the Honorable Tina Campbell, United States District Court for Utah. After a clerkship, she joined Salt Lake City firm of Parsons, Bailey, and Latimer. In March 1998, she joined the United States Attorney's Office for the District of Utah as an Assistant United States Attorney. In January 2005, she was appointed Executive Director of the Utah Commission on Criminal and Juvenile Justice. And in 2006, she became General Counsel to Governor John Huntsman, and she currently serves on several bar committees, one of which is the Utah Supreme Court Advisory Committee on Rules of Criminal Procedure. To my far left, and he's kind of the wild card here, and I'm really happy to have Professor Middleton here. I feel sometimes like we spend so much time As lawyers talking to the lawyers, I thought it would be nice to get someone from a slightly different discipline. He is in the Department of Communication at the University of Utah, and he is the Assistant Professor of Argumentation and Public Discourse, which I have to say is the coolest title I have ever heard. He is director of the John R. Park Debate Society. He has over 15 years of experience competing and coaching competitive debate and public speaking, where he has coached numerous students to the highest ranks of national competition. During that time, he has worked with Northern Arizona University, California State University, Long Beach, and the University of Utah. Dr. Middleton has also worked as a consultant for the International Debate Educations Association and the National Parliamentary Debate Association. His research focuses on rhetoric, argumentation, public discourse, and cultural studies in the context of political advocacy and social movements. His current research examines how homeless populations in Sacramento, California have carved out spaces of democratic participation within their surrounding communities. And without further ado, these are our speakers, in case you're wondering. I'll turn the time over to Ryan.
All right, is this on? Yes. I'd like to thank Brett for disabusing me of the notion that I've had for a long time. You have to be an expert to speak on these. Apparently you don't. You just have to not know how to say no when you're out. That's what I've learned. And I'd also like to thank him for giving me the very coveted post-lunch speaker award. This is what everybody wants to do, is speak to a room of people who don't have that code. Right after the meeting. So hopefully I'll do my best to not put you to sleep. As Brett mentioned, this seminar is about the do's and don'ts of oral argument and opening and closing statements. I can count on one hand the number of opening and closing statements I've given, so I'll leave that to people who have done them or seen them and not just read about them a lot. And just focus my remarks on oral arguments, both in terms of appeals and in terms of motion arguments, which I think carry a lot of the same principles. Justice Scalia, for those of you that read his books, wrote a book a few years ago with Brian Garner. This is if you're following the internet war, this is the one that Judge Posner does not hate. But he wrote a book about, somebody laughed, so somebody caught that. They wrote a book about how to persuade judges, and Justice Scalia addresses the question briefly that we all sort of talk about when judges aren't around, about whether and how much oral argument actually matters. And Justice Scalia's response to that is that in an easy case, as he puts it, or in a case where the result is clear, he doesn't think it matters at all. But then in a case that's close, he thinks that it can matter a lot, because in that scenario, you have a situation in which the judge is theoretically entering the room undecided. And as I've thought about preparing for oral argument, whether it be in the appellate courts or the trial courts, to me that really sort of has to be our framework for thinking about it. We have to assume that we're preparing to talk to somebody who could go either way. And with that in mind, I think there's a couple of things that we can do to address the undecided judge to sort of help make it easier for them to go our way as opposed to the other way. The first thing is I think that it's imperative that we provide a clear statement up front about why we win. In my experience, I'm really becoming convinced that this is perhaps the most important thing that we should be doing. In terms of the clarity, I really learned about this while I was clerking. One of the great things about clerking for Judge Jackson was he encouraged us to go watch arguments a lot, both at the Court of Appeals, whether he was on the panel, or at the Supreme Court. And so I would just go and watch arguments all the time. And Justice Wilkins at the Supreme Court, I noticed something over the year of watching the Supreme Court, which is that he had a favorite question, it seemed, that he would let counsel sort of get into the middle of a complicated argument, and then he would stop them and say something along the lines of, well, what is it that you want us to do? And it was interesting to me, after sort of seeing this question the fifth or 10th time, that you have these attorneys who were so fluent with the minutiae of the case or the precedent, and then he would stop them and ask them what's really sort of on his face, a very basic question: what does he want us to do? And a lot of times it'd be a real pause, and it'd be this sort of mental, refiguring, trying to figure out, how do I answer that really difficult, obvious question. And it was interesting to me. I sort of noticed this over the year, that was something that seemed to trip people up, that people seemed to be sort of preparing almost the wrong thing without sort of doing that first basic step. A couple of years, I've noticed this also at BYU. A couple of years ago, I got put on the mailing list for the moot court team. Those of you that have ever been on a moot court mailing list, you get contacted a lot. It's like political season, twice a year. And so I've ended up doing a lot of judging for the moot court competitions for the last couple of years. And I ask a variant of the Justice Wilkins question a lot. You get these law students who are just really, really prepared more often than not. And they're ready to talk about facts, and they're ready to talk about 15 or 20 different cases. But then halfway through, I'll sometimes just ask them, well, what's the rule? You know, what's the rule you want us to adopt? And that always sort of seems to catch them off guard. They're ready for the really complicated stuff, but they're not quite as ready for the basic thing. And I think there's a reason for this. I've sort of thought about this a lot over the years. And the reason that I think this matters, this question matters so much, is that the briefing can get so complicated. Whether it's in a complicated trial or an appeal, there's so much involved in terms of the facts or the issues or the sub-issues or the sub-sub-issues or the sub-sub-sub-issues. And the briefing has to walk through all of that sequentially. You can't skip any of that. But one of the downsides of that is I sometimes wonder whether the complexity of the briefing, of the written work, can distract, can kind of obscure the driving point, the thing that you win on. So one of the things that I've begun doing as I've begun preparing for arguments, is I very consciously make that a part of my preparation. That's a step on my list of things to do, which is I'll ask myself in one sentence or two at the most, what's the very best reason that I win? And it's tempting to sort of blow that off or to just answer it quickly. But I'll spend a disproportionate amount of my prep time on that one or two sentences and just really force that to be up front of my thinking in one sentence, maybe two, but really one. I mean, in one sentence, what's the very best reason that I win? And I think that if you can sort of force yourself to think through that prism, that really narrow prism, it does a couple of things. First of all, it gives you a great opening. But then the second thing that it does is it ends up giving you sort of a theme that you can use for all the different pieces of the argument. And the opening part of that, I think, is the other aspect of this that I've come to appreciate. We're going to talk about this a little bit later, the issue of how to open an argument. But I'll go ahead and foreshadow it or give a spoiler alert for my answer here, which is that I think that's the best way for us to open arguments, whether it be a trial court or the appellate court. The opening minute or so is the one chance that we have to speak to them without getting interrupted, usually. And that's our one shot. That's our one shot to sort of to do a couple of things. One, speak without interruption, but then two, sort of frame everything and put our imprint on what's about to happen. And if we can give the judges that one answer, I win this case because of this thing right here. I mean, there's all this other stuff that you need to consider, and we're right about all that too. But here's the one thing. Whatever else you think about this one thing, whether it's a policy issue or whether it's the key phrase in the statute that we think goes our way, whatever that one thing is, I think we make a mistake if we put that off or if we let that get buried. But if we can make that the first thing out of our mouth and give them the reason that we win, hopefully when they walk out of the courtroom, that's the thing that's still in their minds, and that's the thing that they have to get over, if you will, if we're going to lose, which we should never lose. So I think that's a really important thing, is giving them that one focused statement up front. The second thing that I thought I'd address briefly is the issue of answering questions. This is also on Brett's list of things that we're going to talk about as a group. And for that reason, I thought about putting it off and just sort of saving my thoughts on that until then. And then it occurred to me that when we start talking about answering questions, I suspect that one of the things we'll all say is that you should never put off answering questions because they're important. And then I thought, well, that'd be a little bit odd to put off talking about how important it is to not put off things. So I'll just go ahead and talk about answering questions a little bit. Two quick points about that. The first is I think that there's a value in consciously preparing for questions. Chief Justice Roberts, all these apocryphal stories, some of which are probably true, about how he's the greatest advocate of his generation before he became a judge. And the story, I've read articles in which he talks about his preparation for argument, and he said that what he used to do is he would take flashcards, he'd buy decks of flashcards, and write a question on each flashcard and then write the best answer on the other side of it. And then the days leading up to argument, he would just walk around the block shuffling the deck and just pulling questions out. And I think it's really noteworthy that he would do that. Somebody as skilled and gifted and knowledgeable as he was, that he would very consciously focus on questions. I think that's something that we can be really conscious of, and I think that helps, to not just sort of assume that we'll know the answers, but to really think all this time into the structure and the opening, and you memorize that first couple minutes, and you try to get that really polished. And if a judge asks a question that doesn't fit the scheme, there's this real sort of mental inertia of, I'll get to that when I get to that, or, that's page 3, and I'm on page 1, and I worked really hard on page 2, so, we'll get there. And there's a real danger there. There's a real danger of not being willing to drop everything you spent the last 2 weeks working on. I learned this as another clerking story. It was actually, I was interning for Judge Jackson while I was in law school. I become good friends with a guy who was clerking for one of the other judges on the Court of Appeals. And there's that row, there's the clerk row in the back where all the clerks sit. And I was sitting next to him during an argument, and this was a civil case, so nobody from my division was there. They're not telling the story. There was a civil attorney who was arguing a civil case, and to be honest, I can't even really remember what the issue was. But what I remember about it is the judge that this friend of mine was clerking for asked this guy a question sort of up front, and the attorney said something effective, "Oh, that's part of issue 2. I'll get to that when we get to issue 2." And the judge said, "Okay." And then they got to issue 2, and it came up again, and the judge asked the question, and the guy sort of deflected it. I mean, he didn't quite deflect it, but he didn't really answer it. And the judge asked it a third time, and it was a little bit unusual for this judge to sort of zero in so obviously. And so I leaned over to this clerk that I knew and said, "What's going on?" And he said, "Well, Judge so-and-so is undecided about this case, and this is the exact issue he's undecided about." And it was clear on that third try that the attorney just wasn't quite willing to go there, or wasn't ready to go there, or whatever the reason was, but he didn't go there. And sure enough, he ended up losing on that issue. And that was a good thing, I think, for me to see as a law student. I mean, it's hard to do in practice, but we're so driven to sort of stay with what we've prepared because we've worked so hard to prepare right. And it's hard to be willing to be flexible enough to drop that if there's a reason for it. And it's not always because the judges are hostile. I had an experience with this just this past week. I had an argument on Monday at the Supreme Court. I picked up a case for an attorney who's retired and just did the argument. I guess the argument can share now. And it was sort of an interesting case, State versus Burial. The defendant had gotten a phone call from a female friend of his, and she was upset because her boyfriend was hitting her. And so the friend decided to do the white knight and drove over with a group of friends and went to the house, and they ended up having a confrontation, and the friend ends up stabbing the boyfriend. And so the friend gets charged with aggravated assault. In a trial, he got a self-defense instruction because he claimed that the boyfriend was charging him. But he also wanted a defense of another's instruction, the variant of self-defense where you defended someone else. And the trial judge would not give it to him, just said there wasn't enough evidence to give him this defense of another's instruction. And so he ends up getting convicted in the appeals. He was arguing that he should have gotten that instruction, and he lost the Court of Appeals and then went up and served. And the argument all along the way had been about imminence. The thing that everybody had been focused on, from the trial judge to the attorneys to the appellate attorneys, had been this question of whether the boyfriend was being violent enough at that moment to warrant stabbing him. And that was what everybody had focused on. And as we were moving it, we do internal moves for all of our arguments. Laura had said, "Well, it really seems odd to me that he could even claim this given that he wasn't there. He gets this phone call saying that she's in danger, but he's somewhere else." And that hadn't really been hit in the briefs. And I thought it was, Laura's smarter than everyone, but I think I'm pretty smart too. So I thought, well, okay, I'll put that on page 3. And so I sort of had this nice page 3 section, the Laura section of my notes. And I thought, well, we'll get there at about the 12-minute mark, the 14-minute mark. But during the defendant went first, he's the petitioner, and one of the justices picked up on this issue. And it didn't strike me that this was sort of a devil's advocate moment, but it really struck me that she was really concerned about this issue, that she had thought of it, and this seemed wrong to her, that this instruction could be given that he was somewhere else. And then another justice sort of picked up on that, and there's this sort of 3 or 4 minute dialogue about, well, how can you really do that? And I had this moment. I had this really fantastic opening page, and I really liked my opening page. It was one of the better opening pages I've prepared. But it just sort of struck me at the moment. It's like, well, this seems to be the thing that at least 2 of the justices are stuck on, and we'll win if this is right. And it's kind of a hard call to make at the table with about 2 minutes before you can stand up to just scribble out the first 2 pages. But I think the key thing about argument is that we have to be willing to do that. And it's not always the right call to do that, but we have to be consciously and mentally willing to pick up on the cues that the judges are giving us. And if they're concerned about some issue that we did not think was important, The final thing that I thought I'd address with my short time is the question of tone. I think it's really important for us as advocates, again, whether the trial courts or the appellate courts, to use our tone to reinforce the idea that we're right, to give the judges something of a comfort level for what it is that we're trying to say. I think there's a real danger on both ends of the tone spectrum. On the one hand, if we come off as pushy or aggressive or jumpy, it can give the impression that we're uncomfortable with our own position. I mean, I think we've all noticed this in other people. We'll go see the sort of prototypical trial attorneys who just seem like they're pushing too hard, and then you wonder, what are you compensating for? Like, why are you so animated about this? Is it really because deep down you know that you've got problems, right? And it sort of can create that impression, but then there's a danger on the opposite end of that if we're not aggressive, if we're not assertive enough, or if we're too passive, that it can convey the subtle impression that we don't really care or we don't really think it's important. And I think this is a hard balance to watch or to find, but I think it's a balance we have to be thinking about. We have to at least be thinking about this. But on the one hand, we've got to let them know by the way we sound and the way we look that this really does matter. I mean, it really matters that the state win every criminal appeal. So we should. And they need to know that we know that. But then the other thing
They need to know that.
I think is important, you do need to know that, it's important. But the other thing about that is that we can't go too far the other way. I mean, and you know, I think we've all done this, where one of the tactics that you'll use in litigation is to try to make it seem like the other side is doing something outlandish, right? To try to make it seem like the other side is really asking the court to do something that's just completely crazy. And I think there's a value if you can get the right tone, the right sort of level-headed tone. You know, that Naked Gun moment, if any of you have seen Naked Gun, there's nothing to see here, the fireworks are going off fine. Some of you will think it's funny. There's this great moment in the Naked Gun where there's a fireworks factory that explodes, and the detective walks in front of it and says, well, there's nothing to see here. He's just sort of trying to tell this whole crowd of people watching this fireworks show, there's nothing to see here. And I think sometimes that's a tactic that people use. They'll try to make it seem like our argument is just really explosive or really outlandish, and I think there's a value via tone of just sort of saying, look, we're asking you to do the sensible thing. And if you say that you sound jumpy, that undercuts what you're saying. But if you say that and you don't sound passionate enough, then that undercuts it on the other direction. And I think that's something that we need to be conscious of that can matter a lot in a close case. It's okay.
And that is an interesting balance. As a civil practitioner, I remember I had an oral argument in front of a trial court, and actually we'll see an attorney who kind of has this technique, who basically he would say what my position was, and then he would say, Your Honor, come on. Okay, we'll hear next from Shay Arguello.
Hi, everyone. Anybody who is in this audience who knows me knows that I'm the wild card up here, and I imagine that everyone is wondering, oh my God, what the hell is this guy going to say? It's always the question that's on people's mind whenever I get up to speak in front of people, because I tend to be very blunt and hopefully speak from the heart and say what's on my mind. But I think that's part of why I'm on the panels, to get a variety of different views on things. I am the crazy, loud trial attorney that Ryan's mentioning. Again, that's me. And so tone or things of that nature, things that I always have to consider. I want to talk to you about just a few things. I have a few minutes, and then I'm going to speak somewhat generally, and as we get into this, if there's more specific questions you have, just throw them out there, and we'll answer them to the best of our ability. But I do just want to preface my comments with the fact that I acknowledge the level of expertise that's sitting in this room, the talented lawyers and gifted oral advocates that are here, so the extent to which I appear to be condescending, that's not my intention. Many of the things that I'm going to talk about that are on my mind in very general terms are things that most of you probably already know. It's in the subtleties of these very general principles that I think we can have a discussion, but I just want to apologize to the extent that I sound condescending. That's certainly not my intention. Before I begin, also, I just want to do a plug for a former colleague of mine at the New York County DA's office, who wrote a phenomenal book on openings and closings. And when I say wrote it, he didn't write it, he compiled it. It's a book called Great Openings and Closings in American History. It's written by a guy by the name of Joel Seidemann. Joel Seidemann is very gifted and talented. Yes. Closer or further? So, what this book does is a compilation of, I think, some of the most amazing opening and closing statements, not only in criminal cases, but civil cases. It's a phenomenal read. You pick it up, you won't be able to put it down, so anybody who does this type of work, get it, read it. Amazing differences between the opening and closings in the criminal and civil trials in the O.J. Simpson case, and basic understandings of how those may have evolved the way that they did and resulted in the way they did. So again, very generally, I see, when I talk to lawyers, typically young lawyers, and I explain to them and express to them my thoughts on oral advocacy, particularly at the trial level, I break it up into three groups is what I focus on. The first segment I talk about is be prepared. I mean, I think that's a given, but what it really means to be prepared. That's the first thing. Know your audience. Again, I think these are things that anybody who's gone to these types of lectures probably heard somebody say at one point. But again, do you really understand what it means to know your audience? Who are you speaking to? Sometimes when I'm making an argument on a motion in front of a judge, I know I'm going to get my butt kicked. I know I'm going to lose, but I'm not arguing with the judge. I'm arguing with posterity. Know who your audience is. And I'm serious. Know who your audience is. Know what you're doing, and understand why you're articulating the arguments that you're articulating. And finally, know yourself, and be yourself. So just kind of diving into those three sections, or three different areas, when I talk about being prepared, obviously know your facts, but I believe to be a good advocate, you don't just have to know your facts. Your facts, you have to feel your facts. You have to be in the case. When and it's easier to do in my former life when I was a homicide prosecutor in New York, it's easy to get in and feel passionate and feel empathy, sympathy, anger, the emotions that kind of espouse and precipitate good oral argument, passionate oral argument. When we're talking about a sexual sadist who has hurt and murdered and maimed people his entire life and is going to spend the rest of his natural-born life behind bars, it's easy to get there. In the life I live now, it's not as exciting to talk about securities fraud, but you got to find it. You got to know your facts, and those facts have to come alive for you, because if they don't come alive for you, you can have a hell of a time getting them to come alive for either the judge or for your fact finder, jury trial. That just takes time. You have to immerse yourself in the facts constantly, and I think if you do it properly, and we've all been there, again, whether it be an appellate argument or a trial argument, if you really have done the preparation, the talking and the interviewing of the witnesses, the multiple meetings that you have with your witnesses, the multiple reviews of the paperwork, there's going to come a time, it's usually for me, it's about a week and a half to 2 weeks before I step into the well. You get into this zone, and everything else in the world just disappears, and you know every single fact, timeline, date, and it's like you wake up at 3 o'clock in the morning and it's there. If you do your preparation right, it'll be there, and it's important. Also know the law. That's always the hard part for me. I'm not a gifted academic. I'm not an appellate lawyer. I like to duke it out in the trial court, and so, but it's nonetheless, it's equally important to know the law and be able to master the cases and speak to any particular legal issue before you walk into the courtroom, because you get good judges who know the law, or want some clarification on issues of law. If you don't know them, you can know all the facts in the world, but you're going to get crushed. That being said, the reality of our world is that oftentimes when you step into the well, this is the most basic thing, be prepared, but there's going to come times when you're going to have to step in the well, and you're going to have to toughen up and do it when you're not ready. If you're going to do this type of work, and you want to follow that golden rule, be prepared, but you also have to feel comfortable with and be able to step into the well when you're maybe not as prepared as you want to be, and you're going to have to wing it. The only way I think that good advocates can successfully wing it is by doing this over and over and over again. say about 10% of it is talent and natural ability, and 90% of it is practice and experience. You cannot intuit this type of work. You just can't. Which is why these things are helpful, these panels, I think, are helpful to give you some insight and talk about things that we do and experiences we've had. But at the end of the day, you know, the advocates are the ones that throw out their cut of teeth. They have to get in and do it. And when you get into the well and you do this and you quickly learn that these are things you can intuit, that's how you get good. And that kind of experience, that kind of practice will save you when, say, for instance, your wife has a baby and you don't get much sleep, you don't have time to prepare, and you got to try a case, or you got to have an oral argument from the judge applicant, who will pick you apart a little bit, and it'll serve you well. So you have to kind of be comfortable doing both things. Know your audience. Again, it seems easy and you know, just the most basic thing, but it's not always that easy. Who are you speaking to and why? Know what you want out of your argument. Really know what it is you're going after. And again, that may not always be that easy to question. Bug people, find your mentors, go to your supervisors, talk the case out with people who aren't lawyers. Find out what they're thinking about your facts and the law that applies to those facts. And you may find out really quickly that you are maybe not so sure exactly what it is you want or why you're asking the questions that you are or presenting the arguments you're making. So know what you want first, and then once you know what you want, you better know the person or the people who are responsible for giving you what you want. It doesn't mean that you surrender your positions, convictions, arguments, ethics. The ends don't justify the means. But you gotta know who to talk to. Don't be afraid to push the envelope. I think this is one of the biggest things I see when I am involved in training young lawyers. And it's less of a concern, I think, when we're dealing with advocacy to a judge as opposed to advocating to a jury. I'm much less concerned, and you should get the judge's thoughts on this, but I'm typically less concerned about offending the judge than I am about offending the jury, because I think a judge has more of an objective ability to understand this kid's just passionate. He believes in what he's saying. I'm objective. I'm going to listen to his arguments. I'm going to accept them or reject them. But I know what the law is, and I'm going to apply the law. I think judges have an ability to do that. They're trained to have an ability to do that. We select them for their ability to do that. Juries, if they don't like you, you're tanked. So I tend to not be as afraid to push the envelope when I think it needs to be pushed if I am dealing with a member of the judiciary. And oftentimes, again, I know, and this is part of being prepared and knowing your audience, you know who the judges are that you can go a little bit further with, make that argument that maybe you wouldn't make, or push them, challenge the judge. We don't work for the judiciary. We are advocates, and I think we all can probably remember a time, for instance, maybe in the context of working out a plea deal, the judge wants you to push a plea deal, but it's something you don't want to do, and there's a lot of pressure maybe to do a certain thing you don't want to do. That's fine, that's their job, but understand what your job is, and don't be afraid to push the envelope, is what I'm saying, when it's appropriate, and in the appropriate fashion. Be an advocate, fight hard for your positions. But again, the only way that I think you get good at this, again, is I push young lawyers often about just get in the well, get in the well, get in the well, get in the well. Do it over. If you're not in the well, what are you doing? You're sitting at your desk? Are you working on something? You have an hour? So-and-so's on trial. Go watch it. So-and-so's making an oral argument in the Supreme Court. Go watch it. Get out of your desk, go watch. And I think that's how you get good at this. Finally, know yourself and be yourself. I think one of the things that your audience is going to pick up on real quick, particularly if they start seeing you appear before them on a regular basis, they're going to know who you are. And they're going to know when you're being sincere and genuine, and they're going to know when you're full of it. And you're just trying to expressing who you are as a person. The mentors and the people that trained me and the people that I continue to look for advice and mentor me do things that I will never be able to do. I learn from them and I take from them what I think I can and adapt it to suit my personality and my particular argument. But whatever comes out of my mouth ultimately is really me, and whatever comes out of their mouth is them. If you try and spend too much time emulating other people rather than just being yourself, I think you're going to run into trouble. Be passionate, be sincere, have integrity, be professional, and I think above all else, this is kind of the irony of what it is we do. Humility, I think, is a huge thing. Ego is an important part of what it is we do as advocates, and I think without ego, we're going to have a complete inability to do what we do. And by ego, I mean simply the ability to know and feel confident that you've done the work, you've done the preparation, you know your facts, you know your law, and that you're confident you can effectively advocate your position. That's fine, but you need to shed the rest of it. And if you can be humble and shed the ego when you get into the courtroom, I think it'll serve you well, whether it be a judge that's listening to your argument or a jury for that matter. The fact finder or a judge, I guess a judge can be a fact finder, but a judge or a jury, in my opinion, doesn't necessarily need to like you in order for you to win the argument. It helps, certainly. They don't need to like you, but you better believe they need to trust you. If they don't trust you and they don't believe in the integrity of what it is you're saying and the basis, you have a foundation, basis for what it is you're saying, you're going to lose every single time, particularly in trial level. You're asking a jury, and again, in the context of the cases I do now, white-collar cases, to potentially send someone to prison for a long period of time for stealing some money. There's no dead bodies here. There's no rape victim here. You want them to send someone to prison for stealing money, they better trust that that's the right thing to do. And it's important to be able to communicate that in whatever it is, however you advocate. So how's that for 10, 15 minutes? Did I stay within my time?
Almost.
Almost? Fair enough. Thank you.
Thank you, Jay. We'll turn next to Judge Chris Jansen.
Well, welcome. Thanks for having me here today. And I actually probably could just pass because Ryan and Jay said pretty much everything that I was going to tell you or try to pass on to you, with a few exceptions. So I promise I will be very short. I can be very short. It's not my prerogative, but I can be very short. As all of you know, a brief and an appellate argument or an oral argument in front of a trial judge are fundamentally different forms of advocacy. The written work and the oral work are very different. They have, in my opinion, they have very different goals. The essential goal of an oral argument is to address the judge's concern. You can write your position and present it in writing, but the oral argument is your chance to answer our questions. And generally, we do have quite a few questions, even after reading the briefs. You might be amazed, I don't know, maybe you're not, but you might be amazed at how often a good oral argument can change our minds and can clarify for us how to rule. Bad arguments don't necessarily change our opinions, but good oral arguments can very likely influence how we rule. In preparation for argument, obviously, the most important thing is to know the facts and procedural history of your case. One very big pet peeve of mine is please include the relevant portions of the record and any critical document or critical transcript in your appendix. You need to think that, and I know this is talking about briefs, not necessarily about oral arguments, but you need to remember that a lot of times we read the briefs at home in our pajamas in our kitchens. That'd be me. And if I don't have the testimony, or if I don't have the contract, if I don't have I don't take the record home with me, that's kind of a no-no. They like us to keep them in the courthouse. If I don't have the relevant documents or the relevant information, it makes it hard for me to really peruse those briefs and really understand the issues that I'm looking at. And clearly there is an art in selecting the relevant documents and relevant information to be appended. One thing maybe to think about is that particular document or is that portion of the testimony going to be critical at argument? And if it is, I would put it in your brief and include it in your appendix. In regard to knowing the facts and procedures of your case, one judge, not a colleague of mine, but one judge has observed, nothing is more frustrating for an appellate judge than being confronted by counsel who does not know the record. Knowing the record is vital, yet many lawyers are unable to tell us during the course of an argument whether, for example, they objected to the jury instruction they are challenging on appeal. Please know your record, and I'm sounding like a broken record because that's just an obvious thing, but please know your record. We'll know it, mostly, but we won't know it ever as well as you know it. Know the relevant precedents, with the caveat that unless Judge Voros is on your panel, during an oral argument is not all that common for us to ask you about particular facts of particular cases, unless, of course, the case is critical, applying the facts of the case before the court is critical to understanding and resolving the issues on appeal. Understand and be able to articulate the essence of your argument and fully grasp the practical and theoretical implications of the legal principles that you are espousing. And that's just a very complicated way of saying, know what you're asking for and tell us why you want us to rule in your favor. Perhaps most importantly, anticipate as comprehensively as possible all the questions that we may ask you. Some of them will be tough, some of them will not be tough, but it is important to go through your briefs, it's important to go through your issues and your case with fresh eyes and write down all the questions that you may get asked. Change places mentally with us on your panel and imagine we're generalists, imagine what issues we may spot and have questions about. It's critical. I would say that obviously the argument should not be just a recapitulation of your brief. It is quite annoying to have a lawyer stand up before us and argue simply straight from their brief, just woodenly recite what was in their brief. In selecting which issues to discuss during your argument, consider the ramifications of the legal arguments that you are making. And there are certain arguments, certainly, that lend themselves specifically to a discussion with the court and try and focus on those. I would say select no more than 2 or 3 of your most important points to discuss during the 15 minutes that you have in front of the Court of Appeals, 20 minutes in front of the Supreme Court. That's not a lot of time. Trial courts do have the advantage of maybe not being so constrained with time limits, but certainly this is applicable as well to an argument in the trial court. It's suggested that to lead off with your most important point, but if there are jurisdictional questions or if there is a logical sequence to your argument, it may make sense to start with those issues first rather than the most important point. For example, say you have a case that deals with liability and damages. If you skip over the liability part because it's not maybe as important as the damages part, we might wonder if you're trying to couch it or if you're trying to avoid that. So if there's a logical sequence to your argument, maybe start with the first step in the issues themselves. Tone, Shay talked about tone a little bit, and so did Ryan. The manner of the interaction that you have with us is important. It is very important, and it can be effective for you, or it could be ineffective for you. The best tone is one of respectful equality. That's what I believe. You are having an argument, or you are having a discussion with another lawyer, and it pays to be courteous, it pays to be respectful, it pays to laugh at our jokes if we try to tell one from the bench. You don't get to tell jokes, but we do. It pays to be dignified, it pays not to be rushed, it pays to skip the hollow rhetoric. We are not jurors, and even though judges may tend to be more accepting of arguments on the edge, certainly in an appellate court, we are expecting dignified, respectful lawyers in front of us. As far as an opening statement or an opening when you begin your argument, and of course I'm speaking here as if you were the appellant. It's obviously maybe a little different, similar, but maybe a little different if you're the appellee. Indicate the length of time that you wish to reserve for rebuttal. That's always very important. We can help keep track of the time, and even though we tend to ask questions into your rebuttal time, we will give you that time at the end. Begin with as Ryan pointed out, begin with a carefully crafted sentence or two, maybe one, that explains why the case is on appeal and what the outcome is that you are seeking. Don't say anything provocative or anything that might require an immediate interruption from the court. Don't give a recounting of the facts. We really have read the briefs, I promise. I can't think of one time that we weren't prepared for the arguments. In conclusion, when you have made your essential points, or when the time is running out, just remind us what relief is being sought, or how you want us to rule. If you are the appellant and there are still points to be made, you can ask us for more time, or you can ask if we could go into your rebuttal time. We're generally very nice about especially if there's only one argument scheduled for that day, we're generally very nice about giving you more time. And if there's a lot of questions, we'll let you have more time. But if you don't have anything else to say, quit while you're ahead. That goes a long way. In answering questions, as Ryan also pointed out, never say, I'll get to that point in a minute. We don't know what page, on which part of your page that point is going to be made. Answer the question, if you can, answer the questions as they come up. I think Judge Orm is wonderful in that way. Maybe not wonderful, maybe I just think it's wonderful, but he has a great ability to take people all over the place. If the question asked involves a peripheral point, and I am the queen of periphery, and I would just say that Chris and Jeff and Nancy and Ryan too, you all are masters at getting me back to where I need to be. Answering my question, but getting me back to where I need to be. Segue back to your main points nicely and easily, and I appreciate that. Never bluff. If a question is unclear, ask for clarification in a respectful way. And never, if you don't know the answer, don't bluff. As Shay mentioned, credibility is the most important thing that you have, and your word is so important. If you don't know the answer, tell us that and offer to substitute at a later time, offer to file a memorandum at a later time, or gently move us on to a point where you have more confidence in your argument. As long as you don't not answer the question at all, we can be easily moved on to other topics. If a judge asks a question about a case, and remember that I did say, with the caveat that we generally don't talk about specific cases during oral argument, if a judge asks about a specific case and it does not ring any bell for you, please tell us that. We're not gonna hold that against you.
Oh, but then Judge McHugh will say, but you cited it in your brief.
But you cited in your brief. Well, she might hold it against you. Keep your rebuttal brief. Take the opportunity to have the last word. That's the most important point. Prioritize the points you wish to cover so that you address the most important ones before you run out of time. End on an affirmative point, restoring the strength of your most important argument. If you are fortunate enough, and most of the time this is you all, if you are fortunate enough to be representing the appellee, you are aware of the slim statistics in terms of reversal, but you have to remember, never be complacent or overconfident. We reverse plenty of cases, and especially if you're smug and you know, overconfident, that doesn't come across well. It is the exceptional case that is wholly unmeritorious or wholly frivolous. Even those cases that seem to be very easy can have good points, and so it pays to be respectful of that. We are an appellate court, but there's also obviously trial courts, and I was a trial court judge for 3.5 years. When you're in the appellate court, remember, arguments shouldn't be pitched as if you're speaking to a jury. I think it pays to remember that there are very different styles that can be very effective in front of a jury, not so effective in front of 3 appellate judges or 5 appellate judges.
How often does that happen? Because I remember watching it. There was a respected practitioner once that I saw doing an argument, and he was really clearly a trial attorney, and he was pacing around and you know, making all the gestures, and the judges were just kind of looking at him like, what are you doing?
What are you doing?
I mean, is that ever effective, or is that something?
I don't think it's particularly effective. And the way that I like to think about it, having had both experiences now, trial courts are places of equity, and emotion can sway a judge to make a decision. Obviously, a decision that is still consistent with the law and the application of the law. But emotions have a bigger place in the trial court. Emotions shouldn't necessarily have any place in an appellate court. And it's more of a place of intellectual debate and legal discussions. That's the hope, and that's what we try to facilitate. And trial strategies are just not necessarily effective in an oral argument, during an appellate oral argument, I should say. We will always be prepared for the oral arguments that you have in front of us, but you will have spent far, far more time studying your case, studying the record, knowing the specific facts of your case. If your appeal involves technical questions or areas of specialized knowledge, please understand that we are generalists and we will do our best, but you might need to tone down your expectations of us and the way that you talk to us during the arguments. Don't use acronyms or, you know, specialized terms of knowledge. We might be easily confused along those lines. You know, avoid ad hominem attacks on trial judges or opposing counsel. That's just a stupid thing, and I know you all know this. But we like civility, and we actually insist upon it, and it doesn't make us feel good at all to refer to trial judges as stupid or bozos or anything like that. We respect our colleagues and know that they work as hard as possible. I don't know, what, I had a few things to say about sort of the difference between trial court and appellate court, but maybe we could just wait and see if anybody actually has any questions about that.
Okay. Thank you, Judge. And now we'll turn to Professor Middleton.
Well, it's great to be here and to be proclaimed the wild card. That's excellent. And I feel like that gives me a lot of freedom. I study argumentation from a communication perspective. My expertise is with argumentation as a discipline, and we would differentiate that from legal argumentation as perhaps a sub-discipline. We tend to think about argument in the communication discipline as occurring in spheres, and there are differences between those spheres. My area of most practice or expertise is with political types of argumentation. That aside, we also believe that there are some dimensions of argumentation that are universal, that apply in all sorts of contexts, and that sort of assist arguers in all of those contexts. And so I'm going to focus on that because I think that the sort of sphere-specific things, the legal argumentation-specific topics, I'm clearly outgunned on this panel. So one of the things that we are quite good at in communication is understanding how audiences interact with messages and how, from the perspective of someone receiving your argument, some of the techniques that the other folks on the panel are talking about tend to function. A theory that we use to describe this in communication is referred to as elaboration likelihood. We ask the question of how do we get audiences to process and pay attention to our message and hopefully listen to the strength of our argument rather than make decisions in ways that we'd rather not want them to make those decisions. We refer to this as high elaboration and low elaboration, the degree to which the audience is spending time processing the material. High elaboration audiences closely examine evidence. They closely examine reason and argumentation. Low elaboration audiences make decisions based on heuristics that already exist, or biases that already exist within the way that they view people or view decision making. Some of the intangibles that other folks in the panel have been talking about, like credibility or manner or tone, tend to control an audience's decision making when they're engaging in what we call low elaboration decision making. So I think we can all agree, right, that we want the audience to pay attention and to think carefully, whether it's a judge or a jury. We want to give them every incentive and every ability to process as carefully as possible what we think are our best arguments. One of the reasons that's good is a couple of things. The strength of judgment that high elaboration audiences arrive at and the durability of that judgment. In other words, how effectively they're inoculated against counter-arguments. Audiences who we examine in sort of experimental settings or in settings where we study instances of effective argumentation, if they've engaged in what we could call high elaboration, processing carefully the argument, they tend to not be compelled by counter-arguments. They've got the arsenal of responses they need from the arguments they've heard. If you're an effective advocate, you're going to provide them and they're going to pick up the sorts of materials they need to be able to respond to a rebuttal or to an attempt to refute those arguments. So the question becomes what allows audiences to do that, right? What allows them to tend toward careful examination of arguments versus giving arguments short shrift or biased thinking or relationships to them. And all the research says the thing that you have to do in order to get your audience to evaluate your arguments in the best possible light is motivate them and give them the ability to understand them. So that's accomplished both on the organizational level of argumentation and at the presentational level of argumentation. Organizationally, audiences engage in more high elaboration thinking when they have very structured arguments to work with, right? When they have a very clear roadmap, a very clear theme that helps organize their argumentation, right? It gives them buckets to fill with the case law, with theory, with the other sorts of specifics and the sub-points, as one of the other panelists referred to, that compose the meat of the argument. So organization becomes a key factor in encouraging, enabling audiences to participate in that sort of processing of your message. The second part of it is using as many possible mediums of communication as you can as an advocate or an arguer. That means focusing on more than just the words you intend to speak, more than just having the perfect page one, right? Is how to engage the audience in every possible capacity you can, through things like dynamism, through things like gestures that aren't so robust that they're off-putting, but that are complementary to what you're trying to explain to the judge, or to your audience, to whomever is making the decision about what you're trying to accomplish. The other thing that this does is it shores up or hedges your bets in terms of low elaboration. right? If you do those things, it builds what we refer to as indirect credibility, right? The sorts of credibility that isn't proven by your legal knowledge or by your ability to cite lots of support for your positions, but rather by the quality with which you deliver those arguments to your audience. That immediately translates into credibility, and that's one of the things that low elaboration audiences make their decisions based on the most, right? Is who do I perceive to be the most credible? If clearly I think you're credible and I think you're not, I'm going to go with the person I find credible and save myself the time of high elaboration thinking, right? Of processing the message. That's just the way audiences work. It's neither good nor bad, it's just what you're dealing with. The second thing, right, is in terms of presentational factors, I think is remembering what someone else was talking about when they were talking about having a clear theme, right? Is remembering that for an audience, having a clear thesis to return to, right, is the best presentational technique to ground them in the argument. That if they get lost in the weeds, right, or in sort of the trees, there's this very clear painting of what the forest looks like. I have a very clear thesis or a very clear theme that's guiding my argumentation. You're doing this in the interest of a principle that we should all, if we're reasonable, be able to subscribe to. All the detailed arguments are there, right, but you can focus on the theme. The second thing presentationally that's most effective is showing that you're absolutely the most competent person in the room, right? This is the ability to say, if you refer to the brief, page X, paragraph 2, it's going to say this, and that's what you're going to find when you look at that. It automatically, right, both encourages the audiences that you're credible, low elaboration. Second, also proves to them that you know the information and you can show them how to use that information to arrive at the same conclusion that you arrived at, right? High elaboration, focusing on the details of the message. So I think that from the perspective of communication, what it has to offer to oral arguments is understanding audiences, right? Certainly there's a lot of work, right? A lot of very careful thinking that goes into constructing any sort of argument. Most of all, legal argumentation where stakes are often very, very high. That doesn't answer the question about audiences. And I think that's what thinking through the perspective of communication allows us to do, is say, what are the common ways of thinking about argumentation? So that's kind of the thing that I would say, if you're trying to be an effective arguer, you want to focus on moving your audience in the place where they evaluate the merits of your message, right? Not whether or not they like you, not whether or not the Democrats had a good day yesterday and I'm wearing blue and that might put you off, right? You want them to focus on the content of what you're saying and the quality of your reasoning. You do that by being strong organizationally. That's what these techniques are accomplishing, is moving your audience toward that. You do it by being presentationally effective. That's what these techniques that these folks are talking about do, right? Is they push your audience towards the durable, strong type of judgment that's going to help you prevail, right? As opposed to a short, immediate judgment that may or may not hold up for you. So that's kind of, I think, the unique contribution I can make. Many of the other things they're talking about, I think, are awesome too. They apply in the type of argumentation I teach, but certainly they're the experts in the context of legal argument. So thanks for having me as the wild card.
Thank you very much, Professor Middleton. You know, I'm gonna, Chi, would you go and see if you could scoot that screen around a little bit so you guys can see it? Because I don't know if you'll be able to see these otherwise.
We don't get to see it.
Gather around the computer.
That's what we'll do.
Stand behind Greg.
Maybe I'll just move and I'll come watch it from here. I'm a trial lawyer. I don't stay at the podium.
All right. I'm going to talk a little bit about openings. Is that readable? It's kind of at an angle, I guess. This first clip it's pretty basic. It's just to illustrate an opening. Well, take a look at it and we'll see what you think.
Thank you, Jeff Ferguson, and may it please the court, Michael Kellogg on behalf of AT&T. I'd like to make 3 points today focused on the issue of plaintiff's standing. And the first point is that the questions that the court would have to resolve in order to determine that the plaintiffs have standing are the very questions as to which the government has invoked the state secrets privilege. In other words, they would have to show not only that there is such a Dragnet program, but that AT&T participates wear a mask.
Now that, I think, is just your example of your basic roadmap kind of opening. And I assume, Judge Christiansen, you probably get a lot of those. Are those helpful? Is it better just to kind of jump into things, or?
It's helpful. I mean, it is helpful. Yeah. That, to a certain extent, that is unusual on my court. I'm not sure that he would have been able to, I would think that there may be a judge or two that would jump in a lot more quickly with the question to focus on what we believe are the important points. But it is helpful, and especially if there are no questions, that is very
Right.
helpful.
How about you guys? Did you have any thoughts on that?
That seemed odd to me. The reason that seemed odd, it seems like the classic roadmap formulation is, I've got 3 points to make. Here's point 1, point 2, point 3. And you give the really succinct version of it so that the judge knows this is where I'm going to go. And that way, I mean, it seems to me that the principal reason for doing that is if they're really wanting to talk about issue 3 and you tell them that's going to be my issue 3, then they know to sort of short circuit you. What was odd about what he did was he started by saying, I've got 3 points to make, point 1, and then he just went with it. And so as a listener, I'm wondering, I mean, if I were the judge, I'd be wondering, can I cut him off now, or is he going to tell me what his point 2 and point 3 is? It didn't seem clear to me whether he was just going to do his point 1, or whether he was trying to do sort of an extended hybrid roadmap with substance to it. Maybe I missed it, but that seemed odd.
I have a question about that. Because except for his saying point 1, point 2, point 3, that 3-minute segment or whatever that he gave was the beginning and the end of his argument, it seemed to me. I mean, so I thought, this is short and sweet. He gets to the point. There's no evidence here. There can't be a case. And he's done. He gets to sit down. I mean, I thought that was pretty effective, actually.
Yeah, I think, I mean, this guy is I mean, he's a attorney for AT&T, he's gotta be good.
You apparently like their phones more than I do.
I do not like their service.
Judge Christiansen, you don't agree?
No, I agree with you. It was just unusual. It was unusual to me because I just can't imagine that he would actually be able to do that, right? I mean, to get to the substance, like you said, he got to the substance, at least of his first point, and I would have thought that there would have been, okay, that's fine, or let's talk about that a little bit more, or no, let's move to the really important point here. I don't know, maybe it was just an easy case, possibly.
So, Brad, it seems to me, I mean, romance can have their uses, right, especially in a complex case, or if you want to, as Ryan pointed out, but it seems to me this is really a boring way to begin his argument. I mean, you have the judge there, he already looks like he's asleep. I don't know if this guy was first or not, but it seems to me that this is a complex case, and that this may not be the best way to be pitching a case like this, right? It's not going to grab anybody, and you're having a hard time now. Presumably, they've read the briefs and have a little more background in what he's talking about, but I don't know, it is a snoozer.
Yeah, he is not the most interesting person that I have. This next case requires a little bit of explanation. It's a post-conviction case. It is called State v. Nash, and it's from the Supreme Court of New Jersey. Right. I wrote that down. Mosquito Nash was an elementary school teacher convicted of 2 counts of first-degree aggravated sexual assault on a minor who was a 12-year-old special needs student called JB. At trial, Nash claimed that the abuse could not have occurred in school restrooms as alleged because JB was always escorted to the restroom by an aide. The school principal rebutted this testimony by testifying that the aide had not been assigned to JB. Later, in a civil suit against the school by JB's mother, the principal contradicts this trial testimony by stating that JB, in fact, did have an aide assigned to him. And this I think, is this is the defense attorney's opening, and this is something that is I think, a good example of what we call an opening hook. Okay, what I liked about that, and it was, I mean, to say, you know, he was convicted based on what we now know is a lie, I think is something that's going to get the court's attention. And a lot of times I think, you know, you hear people open with, and I heard him open with this, and I thought, wow, you know, that's pretty strong. You better have the facts to back that up. And you know, I mean, I think that the record does support that. That is kind of provocative. I'm wondering whether, you know, what he said is that too in your face? Is it, or was it appropriate in a case like this?
It didn't work for me, but I mean, and I don't do a lot of appellate work, but it didn't work for me. I think the very nature of the inconsistent statement itself and why that may have been elicited, I don't think, and again, I don't know the record as well, but it doesn't necessarily speak to the fact that it was a lie. In the nature of the kind of case and the victim that's harmed, too, I think that you have to be careful with hyperbole. And maybe the reason it didn't work for me is because as he's making this argument, he's saying such provocative things as lie, can't get his face out of his paperwork. You know, if you believe this argument, and this is your whole hook, then, you know, this is a lie, you know, but his whole focus is down on his paper, he's shuffling things, he makes a little nervous. And I think if you're gonna start off with something that's that provocative, this was a lie, and that's the only reason that, you know, my client was convicted, then it just, I don't know, the delivery of it just, I don't know, it didn't work for me.
I wonder if Professor Middleton, what did you think of?
I mean, I think that I agree with, well, first, I mean, I agree with the shuffling papers commentary, but I think that there's a clear choice, right, between sort of making an assumption that everyone knows this, right, and making an assumption about here's what I'm going to teach you, right, and I think from the framework of telling someone what they know, right, that's not a good practice, right, that invites them to say, well, no, I don't know that, and I'm not really inclined to believe you're going to prove it, as opposed to beginning the argument from the position of here's what I'm going to teach you, and then providing the knowledge to come to that belief, right, I mean, that's how I think you convince someone effectively in that situation.
Would you have been put off by that, Judge?
I was surprised that the judge, that they went to the judge and she was, I was surprised she didn't like immediately look up and
Well,
roll her
she
eyes.
looked kind of surprised.
Kind of surprised.
I liked it. I mean, putting aside his tone, which is terrible, I mean, he didn't really seem like he believed it was a lie, but if he's correct, he wins, right? I mean, he doesn't just win, I mean, putting aside the substance of the case, if the point of oral argument is to help frame the issue and get the discussion onto the ground where you win, if he's right, that the only reason this guy was convicted was because it's a lie, and he starts out by saying that, then the rest of the argument is going to be framed around that. And then when his opposing attorney stands up, they're going to have to confront that too, right? So if he's right factually, he's now forced everybody to talk about what he wants to talk about. I mean, if he's wrong, it's horrific, because then he's going to look like a liar, and he'll lose credibility to the court and lose the case. But if he's, I mean, if you can back that up, then
Well, I should say that in that the trial court did find, the post-conviction court did find that there was a misrepresentation.
yeah. And if it's essential to the case as he thinks it is, and if you can back that up, then why not? I mean, that just seems to be him picking the ground that he wants to fight on. And if he's right, then that to me works perfectly.
Right. I think that's a good. Her point was that phrasing the statement as "we all know that this is a lie" was a little bit risky, because in a way it's telling the court, including the court in that "we," and the court may not be inclined necessarily to go that way, and it could kind of be off-putting for the court. I think that was Aaron.
I think the reason the judges didn't jump on this guy is because they were bored with him already. He was bored just looking at him. He never looked at the court, he shuffled his papers, his tone is bad, the way he started out was bad. And, you don't want to put form over substance, but that was just bad. The fact that he said that it was a lie, he kind of just tossed it away. It was almost like he didn't even believe it. I didn't believe this guy at all. I was bored with him in the 1 minute that he spoke. I agree.
No, I was going to say, maybe one way to address Bridget's point is that he could have begun with the trial court below found that this was a lie, because of course on appeal, that's a critical issue. The trial court found it, you're already there. But I think what's really telling is what Professor Middleton had pointed out, is that this is a case where the words are the right words, I think, for the most part. It's a good way to begin. But his delivery is just so bad that it completely undercuts the importance of the words.
That's a good point. Okay. Kind of skipping around here. This is another example of an opening statement, and this is from the California Prop 8 case in front of the Ninth Circuit. And this is Charles Cooper, who was representing the opponents of Prop 8. Take a listen to this and see what you think.
The people of California and Americans throughout the country are engaged in an earnest and profound debate about the meaning, purposes, and definition of marriage. The issue is a momentous one, for it goes to the very nature of an ancient and ubiquitous social institution that is, in the words of the United States Supreme Court, fundamental to the very existence and survival of the human race. So this court is presented with, in our submission, this fundamental question. And it is whether the definition of marriage, that momentous issue, is one for the people themselves to resolve through the democratic process, as they did in enacting Proposition 8. Or whether our Constitution takes that issue essentially out of their hands and decides it for them, as the plaintiffs argue.
Now, that strikes me as very eloquent. It's something that he obviously spent a lot of time composing. I guess my question is to Judge Christiansen, first of all, is it effective when people give speeches like that? Does it sound kind of canned, or is it effective?
I mean, I guess it depends on obviously it depends on the specific case and the gravitas, if you will, of the importance important questions. Like I said before, emotion, to the extent that trial courts are courts of equity and fairness, emotion can tend to have a bigger place in arguing before a trial court. Appellate courts are courts of law, and not that trial courts are not, but emotion and fairness and questions related to how a case should be resolved need to depend on the law itself. And though I believe he was very eloquent and he articulated well what was at issue in the case, I would have wanted to hear more concentration on the law itself.
And he does go into that. That was his opening. Any thoughts from you guys?
Well, I think it's an interesting observation by the judge. I mean, there's this debate that's going on in our country right now about the role of the judiciary, particularly when we're talking about on an appellate level. A lot of the social movements that we observed in the 60s and the 70s, 50s, 60s, and 70s were based on appellate courts wanting to do the right thing. It had everything to do with wanting to find for the minority, the grandmother, the affected party, and I think had the appellate courts completely divorced themselves from the emotions or the other things that are subtly at play in the context of the arguments that are made, our history may not have been the same. And so I don't think that, while I think it's appropriate that judges have to be cognizant of that and have to be objective, which again was my point of why I think that sometimes you can be a little bit more forthcoming with your arguments in a certain way than you can in front of a jury. We have to understand that whether it be conscious or subconscious, those kinds of things I think matter in argument. They're relevant, and I don't know whether or not we as human beings have the complete ability to divorce ourselves from those things. So if you're going to be an advocate, I think you have to be cognizant of that and try and get that message in, tug on the heartstrings, hit the human element of whatever it is you're saying if you really want to be effective. I think how blatant, blunt, or subtle you are with that message is a matter of discretion, depending on who your audience is and how salient your point is, how emotional your point is. But it's going to creep in. It's going to creep in.
Can I get the professor's response to that? Because that, I mean, I would put off, politically, I'm already on one side or the other. So I hear that, and I'm immediately put off. And I'm wondering, I mean, is that, I'm wondering, that goes to know your audience, I guess, in that, if I'm, I don't know, I mean, so it's a risk to open like that, isn't it?
I mean, I think it's good to communicate the significance of a decision. I mean, I agree a lot with, I think what you're saying at the other end of the table is making blatantly clear how severely significant a decision is, that this is not a run-of-the-mill decision, right, is probably never a bad thing, right? I think that's going to encourage someone to think twice, to think carefully, and I think that, I think objectivity is a goal, right? I think that people work very hard toward it, and I think they probably rarely accomplish it 100%. And in that world, right, if it's a means of persuasion, right, to say this is significant, it has a human dimension, you ought not disregard that in evaluating the questions of law, you make that argument because it is that significant, right? It is a bigger decision and should touch on more issues, right? I think is what you're saying.
We already know that. I mean, not to disagree with you, but we know the significance of the decision, some of the decisions that we have to make. And I guess, obviously, you cannot divorce yourself completely of emotion, and you cannot be objective every single minute of the day, but have to remember our role, and you have to give us the tools to, which is the law, to make a decision. So,
We're almost out of time. I have a lot more clips I was going to show, but I will show this last one just because it's my one funny clip. This was my idea of how oral argument can sometimes feel, and this is a quote from another jurisdiction, and I think it was a long time ago, but I think it captures sometimes how oral arguments feel. Always happens to defense counsel. They always get off easy. And then I'm thinking, wow, the judges are in a good mood. Thanks very much to our panel.